it to, how do you want it to read?
She thought I did.
Back to the council.
Back to council?
I have two little daughters.
Back to the council?
Sure.
Why is that?
Bipartisan.
Okay.
I mean, say it's a political demonstration and you've got a,
We're supposed to talk, we're supposed to talk about this, are we?
Well, we're going to in a minute.
well, we haven't opened yet, so we can.
Okay.
We're going to go through the
That's
thing.
what we should
on
have
the
read.
On TV.
I got a different.
If you're good, we'll let you ask questions.
First, I got about 5 different words.
1126 in field procedure. See where they struck it out?
Yep.
And then the first one, the very first one.
How are you today, sir?
I'm good, how you doing?
Public assembly means any
Yeah,
meeting.
that's
So Milwaukee got a little snow.
What's that?
Yeah.
Milwaukee got a little bit of
I saw
snow.
that, yeah. Plane ran off the runway there Sunday.
Yes, that's when I noticed
Yeah.
it. Yeah.
Talked to it was my mother-in-law's 80th birthday, and I talked to her on the phone, and she said that they got 4 or 5 inches Sunday morning.
Before the
We-
test comes in.
Yeah.
We talked to our daughter Saturday, and she said it was perfectly
Yeah.
clear. so. You're putting speed checks on Park Avenue.
There's a couple of qualifiers in here. It can't,
Where they come down.
Thank you. This is a continuation meeting for the ad hoc for the parade ordinance permit. Okay, committee members, myself, I'm Charlie Trombetta, Mary Saracino, and John Esposito. In ex officio, we have Paul Rotella, Dwayne Perkins, Ben Chinisi, and Lynn Taversack. Also, tonight is with us Chief Baker, Chief of Police, Corporation Counsel Rick Gottschalk. The reason the meeting was called on a third attempt to try to make sure that this ordinance is as close to possible as being perfect as it can be, especially since I'm the chairman. I want to make sure it's perfect. So, Attorney Gottschalk made some changes and revisions, and apparently they have been emailed to everyone for their review. And can we just go over, Rick, what we changed and why and how?
We sure can. What an adventure through the land of constitutional law this has been for me personally. I'll start by telling you that. You remember where we started was with a model ordinance. And I'm going to call it that because that's what the International Municipal Lawyers Association called it. But upon more careful review, it turned out that it was a model of constitutional pitfalls, rather than a model of something that the chairman of this committee would call perfect. What happened was we met a couple of times, first with Les Pinter and the second time with myself and with you all. And Les, I know, gave you copies of other ordinances that have been adopted in the state of Connecticut. And I believe he also gave you a copy of that model. We reported out of committee, got to the council floor, and in that very week, we received a publication that called into question some of the language of the model that we had used. I then contacted the International Municipal Lawyers Association and was told that this model hadn't been revised in many years. And I will tell you that I made certain assumptions, probably a dangerous thing to do, about the nature of model ordinances that are floated out there in public by an international association of municipal attorneys as being a model that you could count on as at least passing some kind of minimum constitutional standard. Well, not so. It turned out, as I looked at it more carefully and dropped my rose-colored glasses, because I frankly had my own questions about the constitutionality of this model ordinance when I read it the first time. But I made certain assumptions. And so as I took off those rose-colored glasses and started doing my own research, I came to the conclusion that there were a variety of defects with this proposal. I also, as I have done over the last 25 years on a number of occasions, contacted a professor of constitutional law, now retired from Quinnipiac, Professor Martin Margulies, who always knows more, can be counted on to know more than I do when it comes to constitutional law and probably many other subjects. And it was with his help, guiding me to various case law and commenting on these drafts. This is perhaps the fourth draft that I propose this to you. I will tell you that neither Professor Margulies nor I are in a position to guarantee that it's perfect, or that a judge won't view language that we think is acceptable as something less than that. But I will quickly add that this is an awful lot better, in my opinion, than where we started, and was certainly worth the little odyssey that I went through. And so with that preliminary comment on the record, I'll go through this and try and explain for you some of the things that occurred to us as we went through this. First, in the definition sections, what I tried to do was to accomplish a couple of different things. First, I wanted them to at least be comparable. Language that was found in one of the definitions, the one, for example, for public assembly, was good and absent from parades and vice versa. And so what I tried to do was to have them mirror each other more or less, with the operative language being different, namely one seems to be something that's moving down the middle of a street, and the other is perhaps a little broader and not necessarily moving, but I think the words we use are words that, generally speaking, we all can understand. But right now, so that was one of the things I tried to accomplish. The other was I needed to fix a minimum number of people. You can't have an ordinance that could be interpreted as applying to two boys and a dog walking down the street and have no way from the language of the ordinance of determining that this wasn't a parade. And so what I did in the case of parades is add the language which was already in place for public assemblies to say we're talking about more than 25 people. Or in the case of parades, some combination of people, animals, and vehicles. And then I wanted it to, in order to avoid the possibility that a potential applicant might not be clear about what the regulation of pedestrian or vehicular flow was, to limit it to something that an applicant would understand, and that is interfering with the normal flow of pedestrian or vehicular traffic. It's something, that's a concept that we kind of understand. So it's 25 people, they're acting together, they're interfering with or have a purpose which interferes with the normal flow of traffic. And if you want to import something to this idea of what in the world this ordinance applies to, take a look at 1122 sub 11. It's on the third page down. It's a kind of lengthy little subsection. But what it means, what it attempts to say is that this ordinance, this regulation of time, place, and manner in which parades and public assemblies can occur, really is intended to deal with these things that use streets exclusively. In other words, they exclude people from using the street. If in the opinion of the applicant, these people are going to walk down the sidewalk in single file, and people are going to be able to pass them going one way or the other, They don't need to apply for a permit. They have to file a notice with the police chief. Police chief gets to put his set of eyes to it. But that's the idea. We're going to regulate, this ordinance purports to regulate conduct that excludes others. Now I heard Councilman Rotella say anytime somebody's standing in a place, that excludes others from being where that person's standing. And frankly, that's a silly definition, because what we're interested in is use of a street, use of a park. And because I'm standing in a place in a park does not exclude others from using the park, just excludes them from the physical space occupied by my body. So when you're looking at these definitions, you're talking about a minimum number of people interfering with traffic exclusively. Next section I want to draw your attention to is...
Yes.
Excuse me, Rick.
Sure.
Can we take these sections one at a time and go over them so that, Rick,
However you'd like to do it.
Yeah,
It's fine with me.
I'm getting,
Can we-
going back before I
can we
went.
get a consensus of opinion or agreement or disagreement with section 1115 to start with? Mr. Chairman, is that?
Yeah.
I think he only went to 11 because it was a clarification.
Clarification of what 1115 was, yeah. But, yeah, I understand. That's what I want to do. I want to go 1115 right on through.
Okay.
Yeah. But I think, I understand your train of thought was going to describe that, and there was a perfectly good reason to do that. Okay. You can continue.
Want me to continue?
Yeah.
All right, 11-18 describes another problem that we have to overcome. And it's talking about applications, and it's stating some minimum period of time that an applicant has to give the city of Danbury in order to review the application. We started with 10 days. And in conversations with Chief Baker, I was prodding him, pushing him to come to a lower number, because I'm aware of court cases that say 5 days is too long. I meant to give you a quotation, but frankly I forgot to pull it out. But courts have said in one way or another that sometimes speech delayed is no speech at all, is speech denied. So the object of the game is to narrow this, to shorten this period of time, this advance notice that we work with. Now, the chief will speak for himself, but in my conversations with him, he was trying to shoot for between 5 and 7 days. And part of that had to do with state approvals. If you want to have a parade on Main Street, since Main Street is a state highway, you got to get DOT approval. Well, okay, I contacted DOT, ready to explain to them all the vagaries of municipal and constitutional law, and to get them to move from 10 days to 3 days, and what they told me was 90 days. Yeah, okay, fine, that's going to work really, really well.
You forget a speech by that time.
Yeah. If 10 days is bad, 90 days is frankly impossible. And so that left me in a kind of bind, which I, in part, resolved by adding 18 to 18. 11-1818. See that one? That says if you're on a state highway, you got to get the approval of the state first. I've alerted people who need to know about this that they need to go talk to the state about their ground rules, because certainly once the Attorney General's office reviews what DOT's view of the world is, there will be confident in saying some kind of modification to that. But I've been encouraged to propose 3 days to you. 3 days is not a lot of time But it will pass constitutional muster. And although I think it creates an administrative burden for the police department, I think it's worth a conversation for you to have and for the chief to participate in to determine whether or not we can live with this.
Before we go on any further, council members of the committee, I'd like to get your opinions on, first originally 30, down to 10, and now we're down to 3.
I'm fine with that. I think 3 is fine.
John, you are?
Yeah, it's fine.
I'm
you know.
fine too. I'm fine with 3.
And, I mean, in addition, the next sentence says that the chief of police shall waive the minimum if there's a necessity to do that,
There's
so.
an out there.
Yeah, yeah.
So, that's not speech delayed at all, necessarily.
Chief Baker?
That's correct.
When Rick and I originally talked, I think he talked about that was a New York City requirement for a parade permit.
It's Chicago.
Or Chicago. Okay, well, New York City has 40,000 officers. Chicago has about 20,000 officers. We have 150, and 3 days will be a burden on us. But you know, for routine matters, I'd like 5 to 7 days. You know, and you have that out clause here where we can waive that 5 to 7 days. But 3, I mean, it's, in a normal week, some of our officers have 3 days off. I mean, it'll be difficult to, you know, if there's a large demonstration, to muster a large response in 3 days.
My concern there, again, if you feel that the inability to actually muster the officers, that's a safety issue, so that is a concern, I'm sure, of this committee. Now that we've heard Chief Baker's reasoning for going 5 from 3, what do you guys think? Yeah.
Got me, Chairman.
And my concern would be constitutional challenge. That would be my concern.
Would the 5 days propose a constitutional challenge in your, Rick, in your estimation?
Let me put it to you this way. The challenge is something to be avoided. Even if you win, it will cost you a considerable amount of money. I mean, I feel a little bit reluctant to argue in opposition to the chief of the police department. Chief is in the best position to know. But I will tell you that if we had an emergency in this town, I dare say we would have police officers there. We would have 50 police officers if we needed them. And my reaction is that, you know, we lived rather well with no parade and public assembly ordinance at all. There was no obligation to notify people 5 days in advance. Frankly, parades are relatively few and far between. We know the ones that are coming up. There'll be a Memorial Day parade. Be perhaps a parade on the 4th of July and Veterans Day.
When the Yankees win?
When the Yankees win, there'll be first a riot and then a parade. But you know, they're not every day or every week or every month occurrences. And when they arise, I'm hopeful that if we were forced to, we'd accomplish what we needed to do in 3 days. And we would thereby avoid constitutional challenge. I think.
I just have a brief comment along those lines, leaving aside my silly objections. If
Rarely.
someone needs a permit, and they're banking on a permit, I mean, this is not some, you know, spur-of-the-moment thing. I mean, they're planning, they're spending money, they've got lots of stuff lined up for this. My guess is they're not going to wait for the last minute to get it, because if it's denied, they've eliminated their 72-hour window for appeal. They'll probably want to ask the police as far in advance as they possibly can for this permit. I would imagine every single major parade where they're going to be spending money and building floats, they'll be telling the police, hey, we're doing this again next April. In 2007, Chief, we're going to be doing this in 2008, 2009, and whatnot. I think that tiny little window I would foresee would be something like a speech on television, a presidential address, a declaration of war, or something like that, where there's this huge eruption of emotion where people have to come out and they have to do something, stand in front of a church, light a candle, be in a park, another 9/11, something like that. And those kinds of things. A 3-day window, a 3-hour window would be too long. But for the vast majority of events, my guess is to avoid a denial and then to work on that denial via appeal, they would want to go as far out as they possibly could. I don't think we're going to get a lot of last-minute 3-day applications. I would say 10 days, 30 days would be, that would be my guess.
Yeah, I'd like to stay with 3 days. You know, we can revisit it if we find that it's a tremendous burden. I think we should give it a shot.
I agree with the 3 days. I know this is a burden for Chief Baker, but I know our police department will live up to our expectations. And I concur with Paul in regards to that. I think, John, are you okay with 3? I think 3's fine. Okay, let's continue.
I'll next just mention a non-change. 11-19 describes fees. We've set the fee at $100. I have absolutely no doubt that we could demonstrate administrative costs in excess of $100. But I will add that we've received some phone calls and some mail from small groups concerned about the fee. A group that marches for education and collects $1,000 by doing that, only to have to give 10% to the city of Danbury, worries that this might have a significant impact on their fundraising ability. So it's in here as it was originally. Professor Margulies has encouraged us to lower it. The mayor is inclined to stay with $100. I think it's sustainable, but it has practical issues that the council ought to at least consider or be aware of.
I might just comment on that. We removed all the other fees, the police, the sanitation, and everything else. I think keeping the $100 is reasonable. And you've excluded people who take to the streets to protest the Yankees winning or whatever. So I think we should leave the $100 the way it is. Organized groups that are going to run parades, a St. Patrick's Day parade, a Memorial Day parade, whatever. I don't think $100 is good.
I agree with that as well. The $100 fee is, I think, more than fair at this point, and recommend we go on.
All right. The next item I want to draw your attention to.
Are ex officio members permitted to speak while the Corporation Council is presenting the ordinance?
Yes.
With regard to the issue of fees, I disagree with maintaining it at $100 and agree with Corporation Council's proposal to make it $25, particularly in light of subsection B of 1119, which waives the fees for those who are engaged in the exercise of their First Amendment rights of speech. In fact, the idea that we're going to waive it for those who are engaged in their First Amendment, the exercise of the First Amendment right of speech, and charge others, I find it difficult to determine how we're going to decide who is exercising their First Amendment rights and who is not, unless it's clearly for a commercial venture to have a parade of some kind, honoring a religious holiday, St. Joseph's Day, or honoring a saint such as St. Patrick. Is that a First Amendment right? or is it something subject to an administrative fee? In fact, I think we'd be inclined to waive it entirely, particularly since we have subsection B, and I think Corporation Counsel and Attorney Gottschalk has pretty much recognized that, particularly with the advice and counsel of Professor Margulies, who is a former professor of mine at Quinnipiac, that it becomes very dangerous to try to decide who should pay and who shouldn't. And in light of that, I think the committee should entertain keeping it at 25 or completely waiving the fee. And I would put that question to Corporation Counsel. Is he somewhat concerned of the subset of the difficulty in the balance between subsection A and B, and does $25 eliminate some of that difficulty in that balance? Through the chair.
It eliminates about $75 of it.
Touche.
I will tell you this, that the point you raise has been something that I've been noodling for 2 months now, and I suspect that what will happen is that the chief will get an application. He will ask whether or not the fee needs to be waived, and this will result in some kind of lively conversation in the Corporation Counsel's office. Because I will tell you this, parades, public assemblies, by their very nature, are expressive kinds of conduct. It's rather difficult for me to come up with maybe the Macy's Day Parade. You know, even commercial speech is entitled to some protection.
And if I may, with your indulgence, Attorney Gottschalk, to the chair, is that it's exactly the issue, is that even commercial speech is protected under the First Amendment. And so we are in an area of massive ambiguity with regard to whether or not something is speech under the First Amendment. It is.
Yeah, but are we really, we have within the fee subsection a way to waive that for, if it has anything to do with the First Amendment rights of anyone?
I think the point that Tom is making and Attorney Gottschalk is backing up is that any expression is free speech.
And I understand that, then, based on the chief reviewing a permit or an application, then 99.9% of the fees will be waived, the $100 fees.
Mm-hmm.
But it still can be left within the subsection. We're not denying anyone their right to a parade, or we're not denying Chief Baker the ability to assess a $100 fee, which to me is fair. But that's my opinion.
Mr. Chairman, what I'm saying, though, is that how will that determination be made, and the difficulty of putting that burden on the chief to decide what is and what is not free speech under the First Amendment that shall be or shall not be subject to the fee.
So you would feel better just waiving all fees? There's no fee, have no fee?
Have no fee, or having a very de minimis fee at best.
Well, then why
because-
have a fee at all?
Why indeed?
Well,
Why, exactly.
Well, why, right, well, why,
Right.
well, if. we-
If
but
99.9%.
But you would feel better if we put it at a $25 fee as opposed to a $100 fee.
I would feel
So
better.
we have 1/4 of the, we're taking away 75% of the First Amendment right as opposed to 100%. But you feel better at a lower fee.
Well, Mr. Chairman,
That's ambiguous to me.
putting, well, no, actually, I feel better with no fee. But what I said was that I think Corporation Counsel is recognizing that and presenting sort of a balance to the committee. However, I would agree with no fee, with that subsection B should be the prevailing section, the prevailing spirit of the ordinance, and that the absence and the inability to distinguish between that free speech, that First Amendment right, which should be subject to a fee or not subject to a fee, underscores the reason not to have the fee. And if you, as stated, 99% of the time the chief will probably waive it because it is a First Amendment expression of speech, then why have the fee?
Committee members?
I got
I
a
think
quick,
Mr.
Oh.
Gottschalk wants to comment.
Go ahead.
I'm sorry.
Sorry. Go ahead.
I feel somewhat like I'm stepping out of my role as legal advisor exclusively, but I think it's fair to say that fees, at whatever level, are not to be moneymakers. They're just to defray expenses. And from my perspective, parades and public assemblies are celebrations of this community and the best ideals of this country. Whether you're talking about $100 or $25 won't make a whit of difference to the city of Danbury, and might make a big difference to somebody trying to exercise their First Amendment rights.
John?
I don't agree with those last remarks. That, you know, if someone's going to have a parade or public assembly, $100, $25, or some fee, do we get anything in this world for nothing? I mean, there's got to be a cost somewhere along the line. I mean, I just don't agree. I think that $25, $100, or whatever you want to put it, you don't want to put the $100 in there. I would say that $100 is a reasonable fee for a public assembly.
Yeah, Ted?
Again, through the chair, I just want to give some comments to this as well. I think some of the events that do occur that could be considered a parade or assembly is 5K races, which is neither a commercial or First Amendment. It's a race through town, which in my opinion would need to comply with this ordinance as well, if I'm not mistaken. So I think on that basis, I think you need to hold the charity or the organizer accountable for that event. So I don't come down there and I don't waste Chief Baker's time and submit an application for a parade that never exists or never happens. But yet I gave the application, I filled it out, I submit it, and if there's no fee, there's no harm to me, but I did waste Chief Baker's time in doing all this. And could that happen? Sure it could. But if I'm going to go out and spend the $25, which I agree we should have at least $25, it shows that I'm serious about this. I want this to occur. Well, it'd be as high as 100, you know, that could be some charities that could be very expensive. But a nominal $25, I think it's a start to see how much time it does take, and then that can always be escalated as time permits. But I think a fee should be charged to make the organizer accountable to what's happening, and we're not wasting anybody's time.
And I tend to agree with you. If someone's willing to fill out an application to through the police department for.
Hold that thought. Okay.
For a permit, it would show exactly what John said. Everyone, when you're filing an application, if you go for a beach permit or, any type of permit to use it, well, there are application fees that are involved. This is not to make money for the city, but it is to show in earnest that we do have a process. I doubt that if we reviewed any other parade, even the model parade ordinances from any other town, I would dare say that their fees were waived. I think the fee is not, again, not to make money, but to show seriousness on the behalf of the petitioner. So I'm going to stick with how I feel, and I feel that it should be $100 at this point. Paul, last question.
Thank you. Just a couple of comments, not even a question. In response to Ben, I
No
think
comment, no.
it would be easy to institute a non-event clause, a pay or play clause, that if we got, for some bizarre reason, a flood of people coming in and filling out applications and wasting the police's time and never having parades, we could fine them. Fill out an application, don't have the parade, you got to pay the $25. So that would take care of that issue. And we could still do this for nothing. But the other issue is, I did some querying among insurance companies, and we have to remember that this is not just a fee-based application. There is something else that goes along with that, and that is the acquisition of insurance for the event. And it's a lot of insurance. Now, I shoot films, and when we do a film, we normally need $1 to $2 million wherever we shoot. And it can cost us anywhere from $500 to $5,000, depending on how much liability the carrier thinks they're going to be exposed to. So this isn't just the Girl Scouts needing to come up with $25 or $100. They may need to come up with $500 or $750 or $1,000 or $1,200 or $1,500 to cover the insurance. So if you're raising your $1,000 every May by selling your flowers on the corner of Rogers Park, then all of a sudden you need $750 worth of insurance and $100 worth of fees to pay for the police to use your own public property that you've already paid taxes on, because we think you have to do that for some strange reason.
Petitioning the insurance commissioner to lower the
Maybe,
cost of insurance.
maybe you should, but
Because
that's a different, the fact of the matter is that we need these, we are forcing these people to buy insurance to use a public facility, and it could, with smaller charities, simply prevent them, at least in Danbury.
That would,
From-
by having insurance, it would indemnify that particular organization from possible lawsuits that are inevitable, they could not
They may
sustain.
already have insurance, but you're asking them for liability insurance to indemnify Danbury, not
And the
to
city-
indemnify
and the
themselves,
city.
which they've never needed before. So they have to pay $500 for the insurance, and they have to pay $100 for the permit, and they're only gonna raise $800, it's not worth it. So they don't.
I understand.
Okay, that's just, it
Thank
needs to
you.
be pointed out. Thank you.
Mayor?
On that note, I just asked Corporation Counsel, if I may, through the chair, this question. Does B in section 11-21 raise the same problems that B in 11-19 raises?
Same language.
So possibly 99% of the people that apply for the permit also can have an insurance rate.
Some substantial percentage, whatever that is. And yes, we'll go through the analysis. That's what we do.
Thank you.
Who makes that decision?
Well, what I would imagine is that anybody who's in the role of having to make the decision will seek advice.
Corporation counsel.
There's one other section I wanted to bring to your attention, and I have not covered all of the changes, and certainly we can go into this in any depth you like. Two more, I guess. The first one, going in numerical order, is 11-26. It's an appeal procedure. It used to say common council, now says mayor. And the reason I did that was because of the tight time frames involved. It seemed to me that while the common council is just as capable, and some might argue more capable, or of addressing these kinds of questions than the mayor's office is, the mayor is far more accessible. And the idea of coming up with a quorum of council members in a short time frame seemed to me to be problematic. We can change it back. There's nothing wrong with common council other than that. If you're prepared to come out on a relatively short notice, then that would work. And I guess I skipped over, and shouldn't have skipped over, 11-17. This was, by the way, I should mention it, because this was the reason we kind of put the brakes on this in front of the common council to begin with. It's gone now, so it's not a problem, and I think it's going to generate some renumberings, which hasn't been done yet. There were exceptions to the applicability of the ordinance. And these exceptions, similar exceptions, were challenged in Waco. There was a Waco case, Knowles versus, I forget, Waco probably, back in November or December. And the court ruled that if if your purpose behind the ordinance is pedestrian, vehicular safety, then there shouldn't be an exception for various kinds of processions. You can't have it both ways. So the court struck down these exceptions, and I have removed them.
So, may I ask this? So if we have students going to and from school classes or participating in a field trip and walking down the sidewalk, they need a permit?
You know, if I'm their teacher, I'm gonna say, make sure everybody else can pass, move to the side,
So we're going to
please.
use common sense.
We're hoping.
Okay. Okay, so what you're saying, just so I understand, is that while these are removed, they're really not subject to the ordinance because they won't have the intent of interfering with the normal flow of...
I'm hoping that there'll be other ways around it rather than writing in these exceptions, given the revisions we've proposed.
So we can still meet around the flagpole.
Still need right around the flag.
Yes.
Don't block.
Don't block the traffic.
John, just want to revisit the appeal process with the mayor.
I like that 21-man council business, but and the longer we go here, the more confusing it gets to me anyway.
Yeah. All right.
Charlie?
Yes.
I think section 1126 is the best section of the whole ordinance.
11 dash.
26.
Oh, okay. So noted.
Yeah.
Best.
She's in favor of the mayor.
She's in favor. You're in favor of the mayor.
She loves the mayor.
Well,
I am uncomfortable with whatever the opposite of bipartisan is, monopartisan or a partisan office hearing an appeal, particularly if the appeal has to do with speech that's been denied because it's dissenting, even though we're not supposed to do that. We know it's happened in the past, not in this community, but it has happened. I am much more comfortable with an appeal to a bipartisan body, which by definition with the minority representation laws the council has to have. So, as a compromise, would, through the chair, ask Corporation Council if we can include the word "or," and if that would satisfy you could take the appeal to the mayor or to the common council.
I kind of feel the same way as you do.
I would prefer the common council, but I do recognize, if I may, that there is a time limit, and drumming up a quorum could be tough. In which case, the mayor jumps in, and he's responsible to the people, so he says, yeah, go ahead. But if he doesn't, you can still talk to a couple of Democrats or a couple of Republicans on the other body, and they may say, yeah, well, I think we can do this.
I would feel better as well with mayor or common council. This way, it does help out that organization if we can't have a quorum. Yes, Tim?
Thank you, the chair. Just a follow-up to Councilman Rappello. In the event there is common council or mayor, who supersedes who?
That's a really good question, and that's why we've got a corporation council, but we'd have to work that out. I don't know.
So, I mean, I'm more inclined to be with the mayor. The mayor is here every day. The council is not. I think the mayor is in a very good position to represent the city, whether this should be a good parade or not for the city. I don't think the council needs to get involved with the day-to-day issues. So I'm more inclined to leave it as mayor. But also a question to Corporation Council for B, 1126B. I mean, it says in the event that the common council rejects.
It's been changed in the most recent draft,
Okay.
yeah. I
Okay.
picked that up, too.
Yeah,
Okay.
Mayor? Yep.
I just want to comment on the mayor thing. You bring up the issue of partisanship. I'm trying to think of a reason, a real reason that the chief would deny a permit to begin with, given all the constitutional protections that we've been talking about here. The only reasons I can think of that he might deny a parade would be, because of time and place, which really have nothing to do with the opinion of the person making the decision on the quality or quantity or whatever of the speech. I mean, correct me if I'm wrong, but I can't think of another reason that a demonstration inquiry would be denied.
If I could, I mean, you know, if that were the case, we wouldn't need a Supreme Court or an appeals bench, or, you know. We're supposed to act a certain way, but we don't always do that. My point is simply that if it does come to a point where somebody needs to appeal this, and there is grounds, they could appeal to two separate bodies. Perhaps you could even make it the leadership of the council.
If I may, there is a recourse here of going to court. So if...
Boy, we're really spending a lot of money now.
Well,
I mean, we're taking something that we used to
again-
be able to do for 300 years for free, and now looking at a $380,000 legal bill because a guy didn't get his way. I mean, and the city's defending this. I don't just go to court if I'm blocking this. The city is going to court to defend the decision. And that may not be necessary if there's a more flexible appeals
I mean,
process.
you know, maybe I'm a Pollyanna, but I just don't...
Okay, let me just ask you this
briefly.
briefly. What would be the problem with having either the council or the mayor take a look at this?
I think the problem comes down to who, which...
Couldn't we simply make it whoever says yes? Whatever decision is positive is the final decision.
So then what's the point of an appeal? Appeal is a decision, it's not a automatic, oh, come make the
No,
appeal.
no, in
we're
other
gonna
words,
say
if the
yes.
council says no and the mayor says yes, then you got it. If the mayor says no and the council says yes, then you got it. If they both say no, you don't have it.
So then it would be and. It wouldn't be or, it would be and.
Well, again, corporation council would have to work that out, but I mean, to answer Ben's question, who gets the final decision, my answer to that would be whoever would say yes. If the idea is to allow these things and not to disallow them, then whoever says yes, then you're good to go.
It's superfluous.
Thank you, Mr. Chairman. I think people are talking past each other here, and there's really a debate for no reason with regard to who supersedes who in an appellate process. When there's an appellate process and there's an or, the appellant chooses an avenue, and whichever avenue or road they choose, if that road then denies them, they're denied. It's not that one supersedes the other, it's whichever the person making the appeal chooses to seek. So if they seek the council because they think it's a more bipartisan approach and they know they have time, that's one road. If they seek, the mayor as being the quicker road for that appeal process, they've chosen that road. So it's not okay, now we have another appellate level. It's one or the other. And that's how, if we are to decide, or if this body, this ad hoc committee decides to have mayor or common council at the discretion of the appellant or the person seeking the appeal, they live with that decision. That's how I would view it, rather than having another appeal beyond
Another
that appeal.
layer of bureaucracy.
And the reason that the appeal is neat is because when you set up an administrative process like this, particularly when you're dealing with free speech, you need to have due process, you need to have an appeal process, I think, that allows timely speech, as opposed to having to go to court, and by that time,
Yeah.
it's done. And through the chair, I would direct the statement to Corporation Council for pushback if that's incorrect, then to say that we can have the mayor or the council at the choice of the appellant.
What about that?
I certainly like it better than having the appeal go to both and be heard by both. That strikes me as messy and
It is. It's
apt to
time-consuming
lead
and
to
unnecessary and-
upset.
Thank you. Okay, let's move on.
I've used more than my allotted time, so if you have any questions, I'd be happy to try and help.
Okay, then I think let's go back and revisit the things that were questioned, right? The 3 days, I think was the first one we had discussion. I think we have the decide if they're going to stay with 3, or is there a motion to change that?
I express I'm comfortable for 3 days. John?
I would say the minimum would be 3 days, that's for sure.
Second thing is the fee.
Lee? In my opinion, I'm comfortable with the $100. At this point,
I
we
would
could-
put a motion on the floor that we change it to $25. There's no second, the motion fails.
Motion fails. Okay?
Mr. Chairman,
Yes.
I just have a procedural question. The ordinance that's before the committee right now is which form of the ordinance? There's several drafts that are floating around, and the one, as I understand it, is the one that most recently was prepared by Attorney Gottschalk.
Correct.
The one on the legal paper.
And that would have, as I understand it, that has $100 because they have a draft of 25.
What is the draft?
Yeah, no, the draft we have is 100.
This is 100. This is the one I most recently.
We're at 100.
We're at
I gave it
100.
to him.
So here, 150.
He's got it.
No, that clarifies it.
Okay.
And then the other things that
That should be.
All right, in section 11-22, I'll make a motion that we change the language to have it read, any applicant shall have the right to appeal the denial of a parade or public assembly permit to the common council or the mayor. The wording would be at the discretion of the applicant. And that's at least the spirit of it, so.
You're saying the applicant will have the...
Appellant.
Can,
Appellant.
the person who gets denied
Yeah.
gets to choose. I'd like the mayor to, I'd like to appeal to the mayor, I'd like to appeal to the common council. That was the point that Tom brought up
It's
before.
not like regular court. If you're lucky, you just pick a court.
Okay.
I'm happy with that.
And that would change all of the language in that section where it says mayor, it would read common council or mayor. And I'm sure Rick can
Yeah.
put pretty words on that.
Can you go over that once more, Mary? What
Yeah.
was it? Go ahead.
What we would do is change common council or mayor.
On there.
And it would be the choice of the person who is appealing.
Choice. In other words, they have a choice.
They have a
Yeah, they could
choice.
choose either body, either the mayor or the common council to review their appeal.
And that's my motion, Mr. Chairman. Somebody needs to second it.
I could second that too.
Okay. All in favor? Aye.
Aye.
Motion
So
carried.
make that amendment.
Amendment.
Do we have any discussion on that, Mr. Chairman?
We did already.
Our work is going to be in vain if every time we make a motion, we pass it, and we get a discussion on it, we're going to get it from our
We had-
legal eagles here, they're going
I
to
think-
be up or down.
Yeah, we can't, ex officio is not allowed to discuss after motion.
I'm pretty sure you're right.
Yeah.
That issue,
Helps Upton?
through the chair of the Corporation Council, that has been an issue that has come up and been debated, and I can recall that I was actually shut down on a debate under a motion, an amendment that was before the body, and if I recall correctly, that while I cannot vote on the amendment, as an ex officio member, we're still permitted to debate it under discussion. Through the chair of the Corporation Council would ask for clarification.
Rick?
Yeah. I will tell you just that my sense of it, right now, without doing any research, is that the decision to allow or disallow ex officio members to participate in debate is for the chair and the committee members to make. But I will, if you want the real answer, I'm gonna have to look it up.
Okay, at this point, I feel comfortable with our decision, either or, and Tom did help us out to guide us kind of to that direction, so I'm very comfortable with it. If there is any process that has to be changed, it can be done on council, at the next council meeting.
Okay, by me.
Good.
Charlie, do you have a question or clarification? Yes, Corporation Counsel.
Ben? Yep.
Section 11-33 for penalties.
Yep.
What was that, Ben?
1133.
Thank you.
Now, basically, it reads, any person violating the provisions of any section of this article shall be subject to a fine not to exceed $100. So if I have a parade down anywhere and I exceed the 25 people, I don't get a permit, I get nothing, I pay the $100. So am I worse or better off by just paying the penalty?
It depends on how you define worse or better off.
Well, I don't
Sounds
have-
like you're gonna pay $100 no matter what.
I don't have to pay, I gotta pay $100 for the fees, I don't have to pay the insurance, I don't do anything.
You may have to go to jail, though.
Well, I mean, it doesn't say that here, but it's,
But it would be subject to a police officer if you are blocking a sidewalk or interfering.
that's my question. I
Yeah,
mean,
I would think that.
police are not even there because they're not notified, so I can be there, I can get my 25 people for an hour, they show up, I leave.
I don't know, I think
So-
our police department would be there within 1 hour if you're blocking Main Street or.
But
West Virginia.
that's the question of it. Well, I mean, for a $100 penalty, to me, I'd rather pay the penalty. Or if I'm saying if it's a $500 penalty, okay, now I'm,
Yeah, but we're limited to the $100.
okay, but that's my,
Yeah, bear in mind that by state law,
Yeah, we can't.
violation of ordinances in the absence of some contrary statutory language is limited to $100.
Okay.
so can you see per violation? So if I
Each
violate,
individual may be subject to that penalty, but I think the chief has an answer for you.
No, actually, I don't have a question.
Oh, come on, chief.
but could it be per violation of
Yes, it's
of
per
the
violation.
provision, so I can get hit with 5 violations, which is $600, but it's not more, can that be?
And it's a possibility, yep.
Yeah.
That could be in there.
Tom?
I'm sorry, I think the chief had a question. I'd like to say something.
Oh,
The
chief.
chief had his hand raised before me.
Just to Mr. Godchuk, through the chair, I'm still unclear about an item that Mr. Chinese brought up earlier. And the only reason I'm unclear is I've got 2 of them sitting on my desk now, waiting for approval in April. Those are athletic events held on public streets where there's an admission charged. Where does that fall into these definitions?
The answer is that if it meets the definition of parade, it's subject to the ordinance. If it's more than 25 people, it interferes with flow of traffic exclusively, and it's for a common purpose, it's a parade.
Take care of it?
Well, just, I want to bring up the part about the fees then. You're making a significant public policy change here in that right now we charge those people
Thank
for the cost of police protection, which is significant when you run a half marathon. And you're saying that's now a parade, we're not going to charge anymore. I just want you to be aware of that. Well, you brought it up. And I got 2 of them sitting on my desk right now, that's why I asked.
Yeah, Tom?
And following up on that, and earlier I was going to say, I agree with Councilman Chianesi's position, and I sort of withdraw a little bit from the issue of not having fees at all. And my whole thing was fees with regard to those things that are protected under the First Amendment of speech. However, as someone who's participated in half marathons and 5Ks, and I like to run races, I know that oftentimes those are not expressions of speech, but are commercial activities, or at least activities which aren't expressions of speech. Now, whether people debate whether commercial or charitable or for a greater good, that's neither here nor there, but they're not for the purpose of expressing the speech that I would like the freedom to run in a half marathon. And I agree with the chief that those things I would cull out from exception 1119B and also the insurance provision, which is the same sub B, 1121 sub B, which culls out from the requirement for insurance based on Councilman Rotella's concern, for those entities which are, First Amendment expressions of speech or otherwise not blocking the public throughway, which is another exception under 1122 sub 11, I believe. Standards for issuance also would exempt, let's say, the Girl Scouts because they're not exclusively blocking the streets, or a class trip because they're not blocking the streets or using exclusively the sidewalks. However, a half marathon or a 5K, which needs the street to be exclusively blocked off for their use, would seem to be subject to the requiring of a permit, of insurance, and of being assessed expenses of the city. To the chairman, am I correct in that? And through Corporation Council, would that be exempt under this ordinance in any way? Would that half marathon be exempt from paying all those fees? Or would they fall under the sub A parade provision and not a expression of free speech?
I think you have to take the position that something that interferes with the flow of traffic to the exclusion of all else has to be governed by this ordinance. Otherwise, you fall into the Waco trap, which is the exception, doesn't further the purported goal of the ordinance.
If I follow up, then because such an event is not for the sole purpose of public issue speech protected under the First Amendment, then the chief's concern is addressed. You can charge them the fee, you can charge them the expenses of policing that event, and you can require them to have the appropriate insurance. Am I correct in saying that through the
I
chair?
think we've eliminated the police
Charge, the
issue.
fee charge.
In the statute.
It's in there someplace.
Yeah, 1120.
Eliminated, you mean the charge for police protection? Yeah, that's been eliminated.
That was 1119. Was that 1120 or 1119?
1120.
1120.
But, so, and I appreciate that that was eliminated, but when that was eliminated, as if I'm correct, and Councilwoman Saraceno had expressed significant concern about that provision, rightfully so at the time, the exceptions or the cullouts for protected First Amendment speech didn't exist in the ordinance at the time, and that's why the charging of those expenses or those fees were eliminated. But now, we have the separating or the culling out of those First Amendment, those protected types of activities, but we still don't charge the others those fees or expenses as expressed by the chief. Is that correct?
No.
That's not correct. Right.
It's not correct only in this way. When the draft was originally presented to this committee, it contained that exception for public issue speech. You don't see it here because all these changes only reflect changes since this ordinance hit the council dais and was kicked out because of Waco. But in the original drafts, there was an exception.
I'm just looking at the draft before me, which has what purports to be new language underlined and capitalized.
Right,
Okay.
right.
Which is from the last draft, but not from the
Yeah,
original.
this draft shows changes since you last saw the ordinance, which was on the council floor.
Question to Corporation Counsel, please, or through the chair. Bottom line, Tom's question, or no, actually, it was Chief's question, was the marathons that are sitting on his desk. They get charged an application fee, they get charged, they have to have the insurance policy, and do they get charged for police protection or not? No.
That's
Okay, just need the
That's
answer to
my
the
concern.
question. Okay.
not.
Not.
That's what
I don't know.
So is that what we want?
I don't think it is.
That's not what we want.
So is there a way to fix that?
You want another draft?
Well, maybe we just
No.
add a little. Let's hear what you have to say about it. I mean, I see a difference
Yeah.
in that kind of an event versus say,
Yeah,
a
so do I.
parade, Memorial Day parade, in that the people that are entering it are paying an admission fee. Is there some way we could work with that, to make that?
I believe there is.
Paul?
Yeah, just a brief question, Corporation Counsel, do you see, Eric, any situation where someone would have to pay for police protection, police overtime
That's what we're trying to figure out.
in this ordinance?
Not in this ordinance. Not-
But I mean, in any situation now, moving forward, if this were adopted, would there be any
No.
situation where anyone would have to
No.
pay?
That's not the intention.
That's the,
That's the question
And,
before.
and just to follow up, Chief, are there situations now where people are paying?
There are, and the cost of police kind of limits the number of those events. I can see a proliferation of them. Everybody's going to want to run a 5K or a half marathon because it's free. And that's going to present some, it's definitely going to present some cost problems to us, and it's going to, present some, personnel management issues and overtime issues, so.
yes.
Through the chair of the Corporation Council, is there a way that we can fix those here tonight?
Perhaps the simplest way is to instruct Corporation Counsel's office to revise the ordinance in such a way that that marathons and 5Ks are subject to the obligation to pay for services that they use. And we'll see what we come up with.
Can I put that motion, amendment
To the chair.
motion on?
To the chair.
All right, let me make a motion and then
Okay, I'm sorry.
have some discussion. All right, so we're going to make a motion to instruct Corporation Counsel's office to insert language that would require marathons and 5Ks and other events of that type. Well,
Sporting?
I'm just going to say events. That charge, yeah.
There are those little car races too, or they used to. I don't know if it's still-
Not the little Indian thing.
Yeah.
To insert language that would require those types of events to pay these costs, city
Got it.
costs.
Got it.
You know how to do
Something,
All right, wait one second, we need a second and then we'll see this.
I would second that motion, Mr. Chairman.
All in favor?
No,
Oh.
let's, Dwayne had a
Oh,
comment.
well, we can open that, okay, I'm sorry. Dwayne?
It was covered, just to include some generic language for the sporting events, or, because not only do they have running events, they have cycling, they have those little Indy cars.
Yeah, that's a
Yeah.
kind of, wanted, I didn't want to just say just marathons.
Okay.
That's all.
Tom?
trying to, admission-based events, something like that,
That's like, I don't know how to get around the admission.
rather than trying to define all the different, some sort of, something along those lines.
In your corporation council.
Admission-based, rather than sporting, or as a qualifier to sporting?
To the chair, my concern is that if you start defining sporting, or cycling, or running, or anything like that, but that you need to generically say something along the lines of admission-based events, where the entity is charging people to be part of it.
For instance, if you were running a 5K, you charge your entry fee.
Or the little.
For the cars,
Right, okay.
Like.
Mission
I see that, I got it.
Oh, dear.
Yes?
Ability
Oh, I
beyond
think-
disability, cystic fibrosis.
They're not
pledging-
admission.
They're not
based.
admission.
Pledging.
No,
No,
that's not admission.
that's not
are you paying to participate?
No.
No.
Raising
Okay.
the walker.
No.
Pay money to walk.
No, you don't. You don't have to pay money to walk.
No, that's
Do your
not,
You can walk,
pledges, right?
you can walk for free though.
yeah, you don't have
You're
to.
not being charged an admission.
Right. If you're gonna run in that race, you're charging admission to run or cycle or whatever.
Lots of people walk for free.
I'm
All
okay
right,
with
so, as the maker of the motion, I'm comfortable with changing it to admission-based, if you think that that's okay. And is the seconder okay with that?
I'm doing the best I can to follow you.
I know.
Your motion again, Mary?
Was to have Corporation Council draft additional language for the ordinance that would, no, would have admission-based events charged towards city services.
Okay, I'd second the motion.
All in favor?
Aye.
All opposed? Motion carried. Item amendment. Carried. You got it? You got it?
Takes one, okay.
Sorry.
Now, that would be an amendment.
Amendment.
To the,
Right.
so, and then.
To amend.
Okay, and then I guess, anything else?
No?
And I'd make a motion that we recommend to the council the adoption of this parade ordinance as amended at our next regular, no, not adoption, recommend to the council to send it to public hearing.
It's an ordinance, yeah, we have to go to public hearing.
So the way that- so-
You're going to go to the council as well.
I thought,
Yeah,
I'll second
it
the
has to go
motion.
to public hearing, so,
Okay.
I mean, we can't approve it till it's.
At least we get it
been
before the council. I'll second the motion.
Lynn?
Charlie, through the chair, can I ask the Corporation Council just one clarifying question?
Absolutely.
Great. Imagine an event that might have happened, for instance, if the president announced an increase in troop levels and 40 people playing a demonstration outside the Danbury Public Library on the sidewalks and even put like candles on the ground. But we did not go and seek a permit because the demonstration, not only was it free speech, but it was at a time of the day when we didn't feel that we'd be interfering with pedestrian traffic. So we don't go to the chief and ask for permission. We don't pay any fees because it's free speech. We don't get any insurance. Is
What-
my scenario, or will 40 people be arrested?
Nobody gets arrested. What you will do, except perhaps for other reasons, what you will do is you will file a notice with the chief.
Do we have to?
Yes, under this ordinance, if you do not believe that you will be using the sidewalk exclusively, so that you won't
We don't.
interfere
We don't.
with the flow of traffic, you don't need a permit. But you do have to file a notice with the chief.
Where is that?
That is in, that's 11/22/11. You do file a notice with him because he then gets to say, you know what? I'm thinking that you are going to block traffic, and I want you to file an application.
Thank you. Thank you, Charlie.
Make a motion.
No, we didn't vote on the motion for the ordinance.
Ordinance.
The motion on the floor was to recommend to the common
Common
council
council.
that we refer the ordinance to public hearing.
And a second by John. All in favor?
Aye.
All opposed? Motion carried.
this is when they can have everything anytime they want.
Now we need a motion to adjourn.
Yeah.
Well, it's the application.
I think they said
Doesn't
yes.
mean it has or no,
All in favor?
but
Aye.
that's just
Thank you.
scheduled to be.
Thanks,
As
everybody.
amended. The ordinance as amended.
Yes.